Jack Savinsky and Kendra Suel.
Elliot Plumber on behalf of my client who is just entering the courtroom right now.
Good morning, Judge. Joel Shaw on behalf of Jack Savinsky, who's accompanying me here on Zoom.
All right, this is an objection to the referee's opinion and recommendations. I believe that was filed by you, Mr. Blumberg. You want to state those for the record, please?
Sure, Judge. The proceeding before the referee was unusual on a number of fronts, least of which was in the afternoon prior to the hearing, we received a call from the front of the court's office indicating that the hearing was being adjourned, that it wasn't going to go forward. Part of that was that there was a Michigan State Police investigation that was going on relative to some allegations. And so I informed my client of that. At about 4:15, we received a call back from the front of the court saying that referee legal was ordering that this matter would proceed. So we were, first of all, at a significant disadvantage going into the hearing based on the prior adjournment that was going to follow. But even at the referee hearing, we made a very, I think, clear and strong record as to why the matter shouldn't proceed. Again, referee legal disregarded my arguments or decided to go forward. One of the issues that we were there for had to do with alleged denial of parenting time during the preceding summer. We presented testimony that was pretty clear about the health concerns that existed in Mr. Savinsky's home, the medications that were not being properly administered by Mr. Savinsky, and the referee legal didn't find that those were compelling enough reasons to find her not in contempt and to order make up parenting time. So based on those two findings made by the referee, we filed a timely objection, and we were simply asking the court to allow us to have a de novo hearing to present in certainly more detail and perhaps in a manner that the court will find more compelling than the referee did. So we are asking for a de novo hearing.
Thank you. Mr. Shaw?
Thank you, Judge. I agree with Mr. Blumberg on one point, and that is that we created a full and complete record at the hearing before the referee. I think the referee did actually kind of grant Mr. Blumberg's request to not proceed insofar as referee legal elected not to proceed with the ongoing parenting time issues, that being the parenting time issues subsequent to the summer of 2025. My client hasn't seen his daughter since September, the first part of September 2025, and that continues. The defendant here may not like the referee's decision, but I think that's all this really is, except that I also think that this is a thinly veiled attempt on the defendant's part to also extend this period of time where Mr. Savinsky has not seen his daughter. And ultimately, I believe that she should be sanctioned for that. I draw the court's attention to the referee's opinion and recommendation, page 2 at the bottom, second sentence of that paragraph. A finding of contempt and a fine would have also been recommended, but due to the procedural nature of this matter, a formal show cause hearing against the defendant was never set. So I think that's a clear indicator of how distinctly the evidence favored my client. I don't think that this is a proper objection. I don't think it should proceed. I think the court also needs to be aware of a couple other things. One, the state police investigation has concluded. There was no charging request. CPS visited with my client for the first time this past week. They've indicated that they're closing their investigation without any sort of abuse or neglect findings. And we are headed towards what seems to be another referee hearing based on the ongoing denial of parenting time that started the first week of September 2025. I would ask that the court deny the objection. And, unfortunately, we may find ourselves in front of you again on this ongoing parenting time request, but we're certainly going to find ourselves in front of the referee again. Thank you, Judge.
Thank you. Mr. Blumberg, what evidence, if any, that would be new from what was presented at the referee hearing do you have now?
Well, Judge, we certainly the prescribers of the medication for the child weren't available because we were told the hearing wasn't going forward. And I think it's important that the court address that. I mean, a representative from the front of the court called my office, spoke to me directly, and informed me that the hearing was not going to go forward the next day. I immediately called my client and informed him of that. And we called, when we made efforts to contact other people and to inform them the hearing wasn't going forward. And again, referee legal, Judge, part of the de novo process, I'm assuming, is that you would review the transcript.
I have done that.
Okay, well, what is, without asking you what you thought of that, I mean, I thought I made a pretty compelling argument of the reliance upon the front of the court's direction. Without no due respect to the representative of the front of the court, she apparently wouldn't have made that decision on her own. Somebody told her that.
I don't doubt what you're telling me, that there was a mix-up in communication as to whether or not the hearing was going. I don't doubt that at all. My question, though, is what was the result of that? And so I've asked, it appeared to me that you had a full opportunity to take examination of your client, and that was done. And I listened to all of that. Mr. Straw was able to put, I believe, his client and two other witnesses on the stand, and I've reviewed all of that. So my question is, what, if any, additional evidence would be available for a de novo review, or should I make a de novo review just simply based on the outcome that was, or the information that was presented at the referee hearing? So you said the prescriber of medication. I, quite frankly, don't doubt what your client said during the hearing, that in her words, 5 times more was used than was required. So is there any additional information that you want me to be aware of other than that was not contained on the referee's recommendation transcript?
Again, my understanding of the de novo process is the court would be amenable to hearing testimony that's gone on subsequent from the referee hearing. There is new medication, and my client's ongoing concerns about Mr. Savinsky's ability and willingness to learn how to properly administer the medication.
That would normally be true, but in this particular case, the referee limited his holding to the summer parenting time. And so I believe that I would be at this point limited to the summer parenting time issue. And so it would be that information about the summertime, not about anything that, as Mr. Straw indicated, that from September forward during the summer, during the period after the summer parenting time. So any new information would go to whether or not there was a proper limiting of parenting time after Labor Day. In my view, this is all from the summertime only. And I think all of that information is there within the transcript or the video that I viewed of that hearing. So I'm asking, is there any additional witnesses or evidence other than this prescriber of medication that I've already referenced that I need to review in making a decision about the summertime only?
So is it the court's suggestion that you merely review apparently you've already reviewed the video.
I have.
Okay. So, I guess you can determine, independent of the referee's findings, whether or not his findings were supported by the evidence, whether they were appropriate, and whether it was an abuse of discretion. I mean, all of those arguments will be made at a de novo hearing. But again, right. I'm trying to read between the lines of where you're headed in this manner.
So I am prepared, but that's why I wanted to know if you had, as to that limited time frame, whether or not you had any additional evidence that could have been brought in that wasn't brought in. But I do want to limit it to that, because I think that's the only thing that the referee made a decision on, the only thing that I could do a de novo review on is what his limited opinion is.
The child's pediatrician would be available to testify and provide the court with, I think, relevant testimony about the procedures in medicating the child, the significance of not medicating the child correctly. Those were not presented to the referee.
Judge, I don't believe that there was ever any intention to call the pediatrician to the referee hearing. I saw no subpoenas to that effect, and as you know, physicians don't just show up willingly to court hearings. If Mr. Blumberg wants to blow this wide open, I'm happy to do it because I can present to the court that his client perjured herself on the witness stand. I have text documentation of that fact. So if you want to have a brief hearing so that you can hear from the pediatrician, then I will present the evidence I have, and the court can determine what to do with that additional information. But I don't think it fares very well for Ms. Suel.
Well, I appreciate your predictions, Mr. Shaw. Thank you.
You're welcome.
Mr. Blumberg, was there any attempt on your part to subpoena the pediatrician?
No, not to subpoena, but we've had discussions in advance of the hearing, and then certainly I didn't follow through when I was told the hearing wasn't going to go forward.
Let me understand then that the information that you got from the friend of the court was that the day of the hearing.
Yes.
You were told it was not going to go, so you would have had to have
No. I'm sorry. It was the day before the hearing.
The day before, but you still would have had to have a subpoena out for the pediatrician's testimony prior to being advised. I mean, I would agree with you if you had subpoenaed the pediatrician and then called the pediatrician off, and the pediatrician then said, hey, I can't come now that they've put it back on. I get all that, but it doesn't appear to me that you subpoenaed the pediatrician to have the pediatrician available for that day's hearing.
That's correct.
All right. Under those circumstances, I'm going to find that there should be no new evidence allowed, because it would not have been, even if you would not had the error by the friend of the court staff advising you to put it on or take the hearing off and then put it back on, you would not have had the pediatrician there at that hearing anyway. And so I'm not going to allow that. So I am going to base the de novo review, based solely on what the evidence was as it was presented to the referee. Mr. Blumberg, is there any additional argument that you want to make then as to how I should view that de novo review?
No, Judge. I think, again, Child Protective Services would, well, again, that I'm not sure that had any bearing on the summer denial. I know that there was concerns about the hygiene and the mold in Mr. Savinsky's home. The CPS individual would be able to confirm that. My client testified to that on direct examination at the referee hearing.
All right. Mr. Schraw, any additional argument as to the de novo review that you want to make?
No, just responsive to Mr. Blumberg's comment. I think that Ms. Suel had been in my client's home in years. So for her to complain about conditions, I think is a red herring. And as I said earlier, CPS was just in there earlier this week and indicated that they're closing the case. But I do think that goes more towards this issue that's coming down the pipe in regards to the missed parenting time since September of 2025.
All right. I have reviewed, as I've indicated, the entirety of the referee hearing, which would include testimony from Jack Savinsky, cross-examination of him, Tammy Figiel, and Deborah Kuhn, which were the witnesses for Mr. Schraw, and then the testimony of Kendra Suel, and cross-examination of her as well. So I have made copious notes. I've got about 8 pages of notes that I made as to that review. In my mind, the objections are by Mr. Blumberg. Number one, that the referee's finding that the plaintiff's failure to properly administer the child's medication was not good cause to withhold parenting time is contrary to the great weight of the evidence. My review of the testimony was that there were 2 instances approximately a year apart that the defendant testified to involving misuse of medication or improper use of medication. In my view, that did not was not a pattern. There was no testimony of actual injury to the child. I cannot find any abuse or neglect. At best, it was a mistake by the father of the child, of Marley in this case. And so I do not find that there was any impropriety in the referee's decision as to the medication issue that would have given Ms. Suel the appropriate time or reason to totally withhold parenting time that was court ordered for the summer. The next objection is for the referee's finding that the child's general health and safety while in the care of the plaintiff was not a basis to withhold parenting time, was clear error. There was testimony in this case that the father took the child to a festival when the child was sick, that the child had a fever 3 times at parental exchanges coming back to the mother from the father, that the fridge was bare, but then that was somewhat retracted when she said that she had only seen that before the child was born. Then the mother made allegations of mold being at the father's house, but again, there was no indication that that was true after the child was born. And then there was an allegation that the child threw up eggs and other breakfast products upon returning from the father's home to the mother's home, and that the child was basically reversing her potty training after return from the father's home. All of those things appear to me to be normal, natural kinds of things when you're dealing with a 2-year-old that is going back and forth between 2 parents who are having difficulty in their relationship. In fact, it appears to me that there's almost zero relationship between the parents. I do not find it to be unusual for the child to have a fever, to be taken to a festival when the child may be somewhat sick, or to have that going to the festival aggravate that. I don't believe that the mother knew whether there was mold or whether there was food in the fridge, because she was not present and did not testify that she was present to observe those things. She merely made the allegation. And a child throwing up what it ate for breakfast is a thing that happens on a regular basis to 2-year-olds. Whether that's, as the mother believes, the father's fault, or whether that's simply the anxiety and angst of traveling between 2 parents who don't agree with each other in child rearing practices, or have any sort of good relationship, that the child is experiencing the anxiety and that causes the child to have some medical issues. I don't see anything there other than that I can characterize as neglect or abuse, which in my mind would come to some relevance to removing the child in its entirety from summer parenting time with the father that had been previously court ordered. The third objection and the fourth objection have to do with addressing the Child Protective Services investigation. In my view, all of that has to go with to the issue of after the summer parenting time. There was no information at the referee hearing of any specificity as to what the Child Protective Services investigation was about. There were certainly claims made, but there's no facts adduced. And I believe that should be left to the time period beginning in September and moving to today's date. And the mother will certainly be able to litigate that if she believes that that's necessary. This decision will not address that. So my de novo review of this matter is that the referee made the exact right decision. And for all of the reasons listed by the referee, I am adopting that decision as my own. Mr. Straw, would you prepare a short order to that account?
I will, Judge.
Anything else, Mr. Blumberg?
No, Judge, thank you.
Mr. Straw, anything else?
Nothing, Judge. Thank you.
All right. Thank you all very much.
Good day.